Good evening, everyone. On behalf of Markets and Morality and our co-sponsors, thank you for joining us tonight for what is sure to be a compelling conversation. My name is JP Arribiaga, and I'm a junior finishing my first year here as a member of Markets and Morality, or as we call it, M&M. Being a part of M&M has been a cherry on top of my time at Hope College. It is an incomparable experience to be able to meet once a week with the same group of people, each with their own disciplines of preference, but all with the same intellectual passion to seek truth. Our conversations are centered on a specific book, and our conversations are focused on topics such as religion, economics, human nature, philosophy, and morality. In the same spirit, we host speakers on campus to broaden our perspective and travel locally and internationally to expand our understanding of the topics we value. Tonight, we're grateful recipients of the opportunity to host Miss Nadine Strossen, courtesy of Voices of Liberty, an initiative of the George Mason University. We also appreciate our co-sponsors, the Department of Political Science, the Center for Diversity and Inclusion, and the Pre-Law Society. We thank the Pre-Law Society especially for loaning us their advisor and beloved political science professor, Dr. David Ryden, who will serve as host and interlocutor of tonight's conversation. Dr. Ryden has been here at Hope since 1994, publishing numerous books and articles with a special focus on the intersection of religion and politics. Thank you, Dr. Ryden, for hosting this conversation for us. Students, please be aware that our time will come to have questions after the conversation between our two experts tonight. Now, it is my great privilege to introduce Nadine Strossen. Ms. Strossen earned her Juris Doctorate degree from Harvard University and is currently the John Marshall Harlan II Professor of Law Emerita at New York Law School. She's a past president of the American Civil Liberties Union and a senior fellow at the Foundation for Individual Rights and Education, also known as FIRE. Before becoming a law professor, Ms. Strossen practiced in her hometown, Minneapolis, and in New York City. She has received numerous awards and recognitions, including the National Law Journal naming her one of America's 100 most influential lawyers, and several other publications naming her one of the most influential women in this country. Ms. Strossen has authored a number of books and articles defending freedom of speech, including Hate, Why We Should Resist It with Free Speech, Not Censorship, and her most recent book, Free Speech, What Everyone Needs to Know. Will you please join me in welcoming these speakers?
Thank you.
Thank you, and good evening, everyone. Welcome. Thank you for giving up some of your time on this beautiful spring Western Michigan evening. This is a treat for me. You don't know what kind of treat this is for me to be a conversation partner with Nadine Strossen. I have followed her for many, many years from afar. It was kind of fun to find out we both shared some of our formative years in that Mecca of the North, Minnesota. Yeah, thank you, Stephen. We want to make her an honorary member of the Hope College Minnesota Club, so we'll get her some swag later for that. And then we both, in fact, spent a few years practicing law in Minnesota. The big difference being she rose to much greater heights in her legal career. And here I am, a disaffected lawyer in the academic world. So, but we want to cover a lot of ground, so we are going to get to it. We will have, I've got some questions, and Nadine and I will go for 35 minutes or so, and then we trust you will have lots of questions. And we just want to cover a lot of ground tonight. So let's begin. We'll start with a couple of kind of big picture questions, and then we'll home in a little bit. First one.
Before the
yes.
question,
okay.
David, and we agreed as friendly, informal Minnesotans, we will be on a first-name basis with each other. Before you ask the first question, I want to thank the wonderful introduction and David for coming back from Washington, D.C. to be in conversation with me. And I want to say how happy I am to be at Hope College. I've really enjoyed reading about your very special community here and the very special M&M program. In tribute to your college, I'm wearing your school color here. I'm happy that you have a very pretty school color.
Okay, so Nadine, you clearly have had a sterling legal career, and the leadership of the ACLU, the kind of the august civil rights organization, was a big part of that. In recent years, you've really focused on speech and expression. Kind of post-ACLU, why? Kind of what has motivated you to really make that your kind of central work?
Okay, David, and I'm so sorry. I want to also thank Sarah Estelle, who has been my main contact here and has been so wonderful to work with, as I'm sure you all know, who have the pleasure of working with her every day. The mantra of the ACLU is to defend all fundamental freedoms for all people. And for my entire life, long before I became a lawyer, I have been fully committed to those values. No matter who we are and no matter what we believe, we are entitled, by virtue of our common humanity, to full and equal human rights and dignity. I continue to remain committed to that agenda. However, starting about 10 years ago, I saw that there was, from my lifetime, an unprecedentedly increased attack on one particular crucial aspect of that human rights agenda from both ends of the political and ideological spectrum, namely freedom of speech. And David, I don't believe that freedom of speech is more important than equality or religious liberty or privacy or due process or any of the other fundamental rights. But what I do continue to be convinced of, based on my experience and based on my observations and my study of history and other countries beyond our own, is that without the strongest freedom of speech, all of those other rights are not going to remain safe. They all depend on the most rigorous, vigorous freedom of speech that extends even to speech that is very controversial, including speech that we consider to be hateful and speech that is hated. So as part of my ongoing defense of the full range of human rights and civil liberties, I decided that the most strategic use of my time was to focus on free speech.
Yeah, great. So tonight we're going to probably especially focus on campus, right? Speech rights and expression on college and university campuses. So just to kind of get us oriented, sort of kind of big picture, what are sort of some guiding principles, some overarching markers perhaps for looking for kind of robust speech and expression on campuses?
Okay, so let me start with one very basic legal principle that many people don't know, which is the First Amendment with its free speech guarantee only applies to the government. The literal language of the First Amendment free speech clause is Congress shall make no law abridging the freedom of speech. Now, the Supreme Court has long interpreted, and uncontroversially, interpreted the word Congress as meaning all government officials, all agencies and branches of the government. But it does not extend to the private sector. So a state university, a public university, is bound by the First Amendment free speech guarantee, but a private college, such as yours, has no First Amendment obligation to protect free speech rights of any member of the campus community. That said, don't get too concerned, because the vast majority of private higher education institutions has made a voluntary commitment to respect essentially the same free speech rights that they would be required to protect under the First Amendment if they were a public institution. And I understand, and that commitment is voiced through any communication, whether it be a website, whether it be a student handbook, a faculty handbook, recruiting materials. And just to give you the legal underpinnings, all of those affirmations of freedom of speech, academic freedom, give rise to an enforceable contract. A contract doesn't have to be formal, as long as it's an undertaking that is relied upon, let's say by faculty members in deciding to come here to teach, or students in deciding to enroll here, that becomes an enforceable private contract. And FIRE has successfully sued many private higher education institutions to enforce the free speech promises that they make in these kinds of materials. So I'm going to talk about the First Amendment, but I want you to know that that's not literally what we're talking about here. It's your own voluntary adoption of First Amendment type principles. So the First Amendment, despite all of its complexity, the law under it really makes a great deal of common sense. And it recognizes that different free speech rights should pertain to different settings on campus as well as in other places. The Supreme Court has recognized that government property is divided into several different categories, one of which is called a public forum, and that's like a public park or a street or a sidewalk that classically are open for all comers, everybody with every perspective, to voice whatever your ideas are on any topic of concern to you. The analogy on a campus would be that, is that the Pines, I think I was told it was called, sort of like an open area or a quad or a mall. And again, every student should be free to, or other member of the community, should be free to say whatever you want about any topic, as long as the speech is itself legal. And maybe we'll get into where First Amendment rights end in terms of certain direct harm that may be caused by speech. But basically, as long as the speech is legally protected, you can engage in it in places like that. In contrast, if we're talking about what the court has called a limited public forum, that is government property that is designated for a specific, limited, defined purpose, such as a post office or any other kind of government employment, place of employment, the prime purpose is to conduct a certain type of business. And so expression that's inconsistent with that purpose would not be permitted. Here on campus, the analogy would be a classroom or an auditorium such as this, or a science laboratory where the purpose is an educational one. And I defend freedom of speech very robustly, but I would not defend the freedom of anybody to jump up in the middle of these proceedings and start pontificating on a different topic. That would undermine the purpose to which this particular segment of campus is being devoted. And then the third example is what's called a non-public forum. This would be an area where privacy and tranquility and non-speech values are elevated. The quintessential classic example is a private residence, right? And the Supreme Court has said that you have the right to tranquility in your home, not to be disturbed by speakers, especially in the middle of the night. And the same thing would pertain to residential areas of campus, to dormitories or faculty housing. So it's all very common sense.
Yeah, that's a really helpful primer. Your first sort of distinction between the public and the private institutions, let me just slip in a quick kind of legal question, right? So public universities are subject under the Constitution, the First Amendment rights. We see schools like Hillsdale and several other that are sort of more conservative schools who very intentionally forego any kind of funds to ensure that they can be sort of free of constitutional constraints that they think might interfere with kind of mission and those sorts of things. In between that, are there private schools who receive particular types of support and other benefits from the government that at some point might trigger the First Amendment, not in a voluntary sense, but in an actual legal sense?
That's a great question, because the Supreme Court, again, as a matter of common sense, has said if there is such a strong connection between the government and a private sector institution, the private sector institution can be considered to be effectively part of the government and subject to First Amendment constraints. However, the Supreme Court, whether you agree or disagree, the Supreme Court has held in a case that did involve a private educational institution that government funding alone is not enough to convert the private sector action into government action. But let me give you a very current example, David, of that issue, which is pending before the Supreme Court right now. Some of you may have followed this, that there have been complaints by doctors, among others, who have been deplatformed from Twitter and Facebook and other major social media platforms because they voiced opinions and perspectives about COVID, among other issues, that were treated as disinformation by various officials and agencies in the Biden administration. And the argument, and they were deplatformed, and their argument is that that violated the First Amendment because the reason that the private social media platforms removed these dissident perspectives was because of undue pressure from the government. Now, this is a very fact-specific assessment, and it requires what we lawyers often call a delicate balance, because on the one hand, government officials have their own free speech rights, and we want them to be able to exercise those free speech rights to try to persuade platforms to remove speakers that they think are engaging in dangerous disinformation that is going to undermine public health, right? We could even say they have a responsibility as public officials to engage in that kind of persuasion or encouragement. But at some point, permissible persuasion crosses over the line and becomes impermissible coercion. And the allegations in these cases are that the government officials were basically threatening the social media companies. You better take down what we consider to be disinformation, or else we are going to subject you to legal penalties. We are going to withdraw the special immunity you have for third-party content. We're going to subject you to antitrust restrictions. So this is a very live issue when certain ostensibly private sector conduct can be considered to be government action subject to First Amendment limitations.
Yeah, great, thank you. Let's get a little closer to the sort of the title of this discussion, which was how do we think about hate speech, ugly speech on campus? I think the most common objection I hear to sort of broad speech protections on campus has to do with the threat of harm to students, right, who are on the receiving end of ugly speech or hate speech. I've had administrators at our school sort of express concern or resistance to like formal speech protections, lest it would, kind of those speech rights would be weaponized, particularly against marginalized students, minority groups. How would you respond to that? Are the interests of robust speech protection at odds with kind of the flourishing and the well-being of all students, including minority groups? How do you think about that?
So first of all, let me again put on my con law professor hat and talk about the common sense nature of First Amendment doctrine. So it's a very complex body of law, and yet it resolves into a couple core principles that really make great common sense. The government may punish and outlaw and regulate the speech that is the most harmful, including hateful speech that is the most harmful. However, government may not engage in the censorship that is the most harmful. And let me amplify on both of those core principles. The censorship that is the most harmful is what the Supreme Court has called viewpoint discrimination or content discrimination. That government, or in this case a campus, may not restrict or regulate or punish speech solely because of disagreement with or disapproval of the viewpoint, the message, the content, the idea, no matter how hateful or hated that might be. In our democratic republic, it's not for the government to make those decisions about which ideas are hateful and which are not. It is for we, the people. And if we think expression is hateful, we should ignore it, we should refute it, we should try to persuade people not to adopt those views. We decide what the appropriate strategy is in a particular circumstance. However, if you get beyond the content of the speech, its message alone, and you look at it in its overall context, if in the particular facts and circumstances the speech directly causes certain specific serious harm, or if it imminently threatens certain specific serious harm beyond, I don't like the idea, and I don't mean to trivialize that. I know that ideas can be very hurtful, but we have decided that it is more hurtful, more dangerous to empower government to put its stamp of approval or disapproval on particular ideas. But consistent with what's often called this, the emergency principle, if in a particular context the speech directly causes other harm, then it can be punished. So students are sheltered from targeted harassment or bullying, from intentional incitement of imminent violence that's likely to happen imminently, from hostile environment harassment that is so severe and pervasive that it effectively undermines their opportunity for an equal education, and there are other examples as well. To go beyond that, though, to license the university to shield students from ideas that they may view as hateful ultimately does more harm than good. And let me tell you why that is. It's because the notion of hate speech, and I put that in quotes, is inherently subjective. You know, one person's hated idea is somebody else's cherished and loving idea. To use an example that is very familiar to me from my work in human rights, Black Lives Matter advocacy. Many people consider that to be the epitome of loving speech, right? It's advocating equality and dignity for people who have historically been marginalized and oppressed. But many people, including powerful politicians, have argued that Black Lives Matter advocacy is hate speech. They've argued that it's hate speech against white people or hate speech against police officers. Let me give you an example that may be more directly relevant here on a Christian campus. In European countries and Canada and Australia, New Zealand, other countries that do allow government to punish hate speech defined only based on the allegedly hateful content of the speech. Many Christian ministers, Protestant ministers, as well as Catholic priests and imams, have been criminally punished simply for reading aloud certain Bible verses that are deemed to be, by the government officials or the prosecutor or the juries, deemed to be hateful against women, against lesbian and gay, LGBTQ people, and so forth. Harmful as hateful speech that doesn't satisfy the emergency principle may be to our emotions and our psyches, I think it's far more harmful to empower any authority to punish that speech. And if I can make one other point, please, it is that social psychologists and mental health counselors and experts have said that even from the perspective of the emotional and psychological well-being of students and other people that we think we are protecting by shielding them from hateful ideas or expression that falls short of the emergency standard, we are actually doing them more harm than good, because we are increasing their levels of anxiety and depression. We are disempowering them from developing the resilience and the self-confidence that is going to be necessary in order to be functioning, happy adults in the larger outside world. And all of us can learn the skills to withstand the slings and arrows of hurtful, hateful expression. You know that old saying, sticks and stones may hurt my bones, but break my bones, but words will never hurt me. Of course, that's not literally true. Words do hurt us every day. Somebody just wrote a negative review of my last book, and I don't mean to trivialize it. I know there is much more shocking speech, but all of us have been hurt by speech. The reason our parents recited that nursery rhyme to us was to exhort us not to let the words hurt us, right? To develop our own mental habits of resiliency, that if anything, we would look down on the people who are so benighted as to be saying hateful things about us or about other people.
Can I just ask you to talk a little bit? We'll wade into the source of controversy for the last 6 months, which were the attacks in Israel in early October, and then what has happened on college and university campuses since then, right? Which is a lot of speech, and some of it not very attractive, some of it pretty ugly. It seems to me that might be a good example of the subjectivity of it being either hateful, perhaps if you're on the receiving end, versus viewpoint. Some of those folks protesting, right, grounded in policy viewpoints. Right, 3 college presidents, famous or infamously appearing before Congress and saying, "Well, it's contextual. The answer depends." Yeah. Like, how would you? Well, so how would you think about that?
As a technical matter, from what I've already said, their answer was correct. Whether a particular expression may be punished consistent with First Amendment principles, which they were all espousing, even though they're private campuses, they had said that we would agree to be bound by the same free speech principles. Whether the expression is punishable or not depends not on the message alone, right? Because that would violate the viewpoint neutrality principle. But if in a particular context it constitutes targeted harassment or bullying or part of hostile environment harassment, then it could be subject to punishment. I think what was deficient in their answers were several things. Number one, that the fact that speech cannot be punished does not mean you do nothing. It was mentioned in the gracious introduction that I wrote a whole book called Hate: Why We Should Resist It with Free Speech, Not Censorship. The only verb in that title is resist. It was a call to arms, a call to action, if you will. We should resist hateful speech and hateful ideas, and we do it by raising our voices, not by suppression. So, that absence of a condemnation, a clear condemnation, was quite disappointing. Secondly, there have been widespread reports and detailed reports of many instances on all three of those campuses where the emergency principle was satisfied. First of all, there have been reports on each of those campuses of actual violence against various students, Jewish students and Arab students and Muslim students, that apparently were going unprotected. This should, unpunished, and this should go without saying, but apparently it doesn't go without saying, that violence and assault are not protected expression, even if by committing that violent act you are intending to convey a message, right? My husband teaches at Columbia, and there have been a number of assaults on students that were identified as Israeli or as Jewish because they were wearing the yarmulke, which is worn by many observant male Jews. And I'm sure, and the students who attacked these victims were making statements that were anti-Israel. That is not enough to convert a physical attack into protected expression. Secondly, there have been many reports, and they've led to complaints against all of these campuses now by the Department of Education Office of Civil Rights of hostile environment harassment. And that is when there is a pattern of conduct, including expressive conduct, that is sufficiently objectively offensive, severe, and pervasive that it deprives the targeted individual or group of an equal educational opportunity. And I've read some of the complaints against these campuses, hundreds of pages of hundreds of detailed allegations where the particular complaints I read were about anti-Semitism. I've heard that there are problems on many campuses that extend to Palestinian and Muslim students as well, that these students are so intimidated that in some cases they're not even leaving their dormitory rooms. They don't feel free to go to libraries or other places to study because of the pervasive intimidation and harassment. So it was, and again, the allegation is that these violations of, excesses of unprotected speech are not being punished. And let me make a really basic point, David, which, has really come home to me after October 7th in a way that it didn't before that. And it may be odd for an advocate of free speech to say this, but I have realized very dramatically that if we are to have meaningful exercise and enjoyment of free speech on our campuses and other venues, it is equally important not only that speech that is protected constitutionally should not be punished, but it's equally important that speech that is not constitutionally protected should be punished, because the consequence of not disciplining those who engage in targeted harassment or bullying or hostile environment harassment, the consequence is that they are violating other people's freedom of speech. If you feel so intimidated that you are not going to speak yourself, or even worse, you're not going to exercise your freedom of movement, you're not free to move about campus or to all areas of campus. So that was the second problem with their testimony. And one more problem, which is the hypocrisy. These were presidents who invoked fidelity to free speech principles to defend very controversial speech that many people saw as hate speech, as advocacy of genocide. And yet you look at the records of these campuses before October 7th, and every time there was the slightest complaint of a potential microaggression or insensitivity on the basis of any other demographic characteristic, particularly race or gender, that they would immediately punish it without any concern for free speech. So many people felt that given the inconsistency, that the reliance on asserted free speech principles was just a pretext for turning a blind eye to anti-Semitic hate speech and advocacy of anti-Semitic genocide.
Yeah, very good. I wanted to sort of pick up on the kind of, protests happening on campus and how far is too far. But I'm hoping someone will pick that theme up maybe in the Q&A, because I want to ask a couple quick questions more specific to Hope College campus, and before we move into student questioning. One is sort of the mission, how the mission of an institution might kind of influence, kind of speech policies and attitudes towards speech. So Hope is a Christian college. The mission speaks of academic excellence in the context of the historic Christian faith, right? How does that impact a private school and how it sort of approaches ensuring, robust speech?
Great question, because a private sector institution such as this one has its own First Amendment freedoms of speech and association to shape your own community in a way that is consistent with your own values. And I said the vast majority of higher education institutions do voluntarily adopt essentially First Amendment free speech principles. The major exception are religious institutions, which say that we want to create a certain kind of community where we will espouse or follow free speech practices that are consistent with our religious values. Now, what that means in practical policy terms varies very widely. So there are many religious institutions that say we will completely support freedom of speech for all viewpoints on religious topics and philosophical topics. They don't have to accord with the doctrines of the particular faith that is reflected in this institution. And the opening statement in your free speech principles say that very strongly. But others may make a different decision. I have to say that just this morning, I read an op-ed in the Wall Street Journal by a professor, a Jewish professor who was running a Holocaust and Genocide Studies Center at Clark University in Worcester, Massachusetts. And she was so subject to anti-Semitic, anti-Israeli harassment and hostility, and deplatformed on her own campus and other speakers that had any connection to Judaism or Israel. I mean, according to her, that she felt completely unwelcome on her campus and had decided to go to a Catholic college, which pledged that there would be freedom of speech for her perspectives, that they would protect her against deplatforming, but also protect her against anti-Semitic harassment. And I thought, so that's interesting. They have a religious mission, but it is one that they interpret as being welcoming to different religious as well as political perspectives. But it is the freedom of choice of the institution.
Yeah, great. Thank you. One final question before we throw the floor open. Get your questions ready, folks. This is completely different. I don't know if people have noticed, but we are well into a new election cycle.
Oh.
Yeah. And one that
well,
is...
it feels old, doesn't it?
Yes. Haven't we done it? Deja vu all over again? Yes. But one that is sure to engender some strong feelings and Yes, lots of speech, I'm sure. I'm a political scientist. I teach parties and campaigns and elections. On our campus, we have Hope Democrats and Hope Republicans, student organizations. And I love the idea of candidates having rallies and coming to campus and sort of having that on our campus. The powers that be up the administrative food chain don't necessarily share that point of view. I think they're much more concerned, rightly, what could go wrong when you have more overtly sort of political kind of campaign events. Can you give me something to take, like, to my conversations with the administrators? Or what kind of recommendations around those sorts of things that would make for opportunities for political speech, but also kind of dampen the dangers of, ugly things happening?
It's interesting because it sounds like your administration is not making a very common error that other college and university administrations have made, which is mistaking their own institutional obligation under tax laws not to engage in partisan political activity. Some of them say, oh, that means we can't allow these rallies to take place, or we can't allow the campus Republicans or Democrats to table for candidates. No, no, no. As long as it's not the university itself or the college itself endorsing particular candidates, if they are providing, going back to your first question, David, an open forum where all candidates or diverse candidates are invited and can present their views and be subject to questioning and discussion and debate, that is endorsing nothing other than the importance of these kinds of conversations for the educational benefit, not only of the campus community, but of the larger community. I mean, these are people who are vying for the most important positions in government, and our future as students and as citizens depends on what their policies are. I can't think of a more important educational opportunity than to hear them at close range, to hopefully to hear counter perspectives. You could have panels afterwards, commentary from you and other expert faculty members. Hopefully, they would open themselves up to questions, direct questions from students. And the Supreme Court has said that even though the First Amendment is written in completely neutral terms, Congress shall make no law abridging the freedom of speech. All speech is treated equally under the amendment. The Supreme Court has said that speech about public affairs, particularly in a political campaign, is at the apex of First Amendment importance, because the right to speak, and let me put a parenthesis here, David, freedom of speech includes not only the right to convey information and ideas, but the right to receive them. And the Supreme Court has said, especially in a democracy where we, the people, to quote the opening words of the Constitution, we wield sovereign government power, how can we do that responsibly unless we can hear from those who are seeking to represent us, to be accountable to us? So the Supreme Court has said that speech in a political campaign, in an electoral context, is so vitally important. It is not only a matter of individual freedom of expression, it is the essence of self-government.
Nadine Strossen is on my side. I wish I could make those arguments as fluently as long as I get a copy of the recording. We're good. All right, people. It's your turn. So I don't know if we have microphones that will be sort of taken around the room. But yeah, what kind of questions do you have?
Hi.
Is the soundbite society that we have now interfering with our ability to fully understand free speech? Do you know what I mean by that? I'm speaking from a psychological perspective.
Oh.
But everybody seems to want to take everything in very brief period. They really don't seem to understand or want to take the time for other perspectives.
Yeah, that's a very interesting point. The soundbite society, I had not heard that phrase before, but I've read many studies that have shown that our attention span really is decreasing. That what used to be so the example that I'm thinking of in particular are just focused on the New York Times itself, the length of quotes that it would have from political speeches or from major events. And it used to be, like fairly recently, the typical quote would be 2 paragraphs long, and then it became shortened to 1 paragraph, and now it's like, a soundbite. So we seem to have lost the will or the ability to concentrate. And you mentioned psychology. I wonder if you're familiar with the work of my sister-in-law, Marianne Wolfe. She studies literacy. She's a psychologist who's was at Tufts University for many years, and she's combined psychology with brain studies, and you can show with the plasticity of the brain that since the advent of the internet and social media, that our brains have already demonstrably altered, and that the portions of the brain that can concentrate on complicated literature, for example, are atrophying. Well, I'd say that is a challenge, but that all of us, and I've got to learn this myself, all of us should learn how to communicate effectively in shorter segments. But as I'm laughing because the questions are so complicated, and if I were to reduce the answers to a soundbite, it would really impoverish the understanding. On the other hand, if droning on and on, people are going to stop listening. That's not effective communication either. Now, do you have an answer as a psychology expert?
Opinions and thoughts, it doesn't seem like nobody gets any in-depth into anybody else's idea. If I think about the difference between Black Lives Matter versus, Police Lives Matter, whatever, let's just say something like that, I mean, people just immediately,
right.
their hair goes up,
yeah.
Depending which side you're on.
Yeah, or from the river to the sea, which we're seeing on campus everywhere, and people aren't even... People don't even know what it means. I mean, there have been, and I've done it myself at Columbia, which is right around the corner from where I live. You go up to a student, they literally don't know which river and which sea. It's just a slogan. And I was saying in the discussion I had with some M&M students before this that many experts on civil discourse and negotiation and having uncomfortable conversations say that one of the problems that we start with is that most of us are not inclined to genuinely listen to somebody that we are talking to, that we don't really hear what they are trying to communicate. We are processing what they say from the perspective of preparing what our rebuttal is going to be. And so, one of my friends said, so many of us are taught how to speak in school, but how many of us are taught how to listen? And I think that's the issue that you're raising, and it is on the agenda and consciousness of people who are looking at how do we fix the broken civil discourse. So thank you for that.
I think there was a question back here.
JP, you said earlier, talking about, you made this point that said government may outlaw speech that is harmful but is not allowed to censor. Could you kind of distinguish the difference between outlaw and censor in that instance?
Yeah, and I'm so sorry. You took your note, either I misspoke and or your notes are not quite accurate because I'm using government restriction or censorship or punishment or regulation synonymously. So let me repeat the point that I made, which is that government may outlaw, censor, restrict, regulate the speech that is the most harmful, the most dangerous, because it satisfies the emergency principle. It directly causes certain specific serious harm, or it imminently threatens such harm. Conversely, government may not engage in the censorship, restriction, regulation that is the most dangerous, because it's based not on an emergency, but based solely on disapproval of the message of the speech. Exactly. True threat, intentional incitement of imminent violence, targeted harassment or bullying, fighting words are the major examples. Does that clarify? Thank you for giving me the opportunity to do that.
We have another one here in the front.
So do you think since there's been a crazy rise in anti-Semitism since October 7th, and like we've seen on public universities just a lot of just like protests that are like against Jewish people. So do you think that there will be a change on these like universities, like with their policies, like toward like ethnic groups and like more protection for them? Do you think like there will be like more punishments for like people that engage in anti-Semitic activities, or do you think it's just going to kind of like ride out until it kind of just goes away at this point?
It's interesting. Let me start by saying shortly after October 7th, I was reached out to by a woman named Barry Weiss, who is the publisher of the Free Press. Barry is one of the strongest crusaders against anti-Semitism in the whole world. She wrote a fabulous book about it a few years ago. She is also one of the strongest defenders of free speech. And she knows that I'm the daughter of a Holocaust survivor, married to an Israeli. I could, absolutely loathe anti-Semitic speech. And, I'm not going to say but, and I fully defend freedom to make anti-Semitic statements if they do not satisfy the emergency principle. And Barry, to her credit, like on October 8th, reached out to me and she said, we need to have a piece in the Free Press about why even anti-Semites deserve free speech, and you have to write it. And I did, and one of the reasons why I so oppose censoring speech based solely on a reprehensible viewpoint, such as anti-Semitism or, anti-Islam or anti-anything, any group, is because no matter how well intended it is, it ends up doing more harm than good. Many people have said to me, well, you're the daughter of a Holocaust survivor. If only they had punished hateful anti-Semitic speech in Germany, then Hitler wouldn't have risen to power and the Holocaust wouldn't have happened. That's not what history shows. In fact, you know this, but many people don't, that in the Weimar Republic, during which Hitler rose to power, there were very strong anti-hate speech laws which were very strictly enforced, including against leading Nazis. Hitler himself was banned from public speaking in many parts of Germany for a couple of years. And publishers of anti-Semitic newspapers were imprisoned. And, the Nazis welcomed these trials and prosecutions because it drew attention to them that they otherwise would not have received and garnered sympathy that they otherwise would not have received. The problem was the failure to punish actual violence or assaults. And unfortunately, I draw no other parallels, but that is a parallel I draw on campus. So yes, I am concerned about not the vicious ideas, those we have to counter through education. You're never going to criminalize or punish an idea out of existence. And as an educator, going back to your excellent point, I see these warring groups of sloganeering demonstrators on the most prestigious campuses in the country, in the world, shouting these sound bites at each other. And I am upset as I am as a human rights advocate, upset as I am as the daughter of a Holocaust survivor, I'm at least as upset from my perspective as an educator. This is the antithesis of the kind of reasoned discourse that one would have about the complicated history, the complicated politics, so let's not ban anti-Semitic expression that is solely conveying a hateful idea, but let's try to educate people in depth about the very complicated, difficult issues that can't be effectively summarized in sound bites.
Thank you. We have another question here towards the back.
Hi. Sorry. Thank you for your talk. That was really awesome. I was curious as to how you see a connection, if there is one, between like mass desensitization from media consumption to a limiting view of the effects of hate speech and the actions that could occur. Because I'm thinking like 60, 70 years ago, Emmett Till's body being published in a newspaper has a grand effect on the civil rights campaign, and like legislation gets passed in a year, 2 years afterwards. And then recently, like I've seen a video of a black man being killed by a police officer, and that did far less than one photo did 60 years ago. So what kind of role do you think the media and desensitization plays in the spur to enact social change? And how can you curb that and focus on the actual history of what's been going on?
You know, it's interesting. I'm assuming that you're referring to George Floyd. And if so, I would, with respect, dispute your characterization of that as not having had much of an impact. I mean, that murder really galvanized and catalyzed the Black Lives Matter movement, which had existed before, but it was exalted to a whole new level and has propelled enormous policy changes, not only on campuses, but at every level of government and throughout our culture and throughout our corporations, to the business sector, to the point that some people believe that it has gone too far, that there's been an excess. For example, with the commitment to DEI values, which fundamentally I would hope are incontrovertible, but many people are now arguing, well, that it went too far, becoming too formulaic. But all of that was triggered, I believe, by a revulsion at seeing this murder on camera. And let me say that the ACLU has, throughout my entire involvement, which goes back ancient times to the 60s and 70s, for many, many decades before it had any public traction, was crusading against unjustified police killings, including disproportionately of young black men. We began a very serious campaign in the early 80s. Didn't get too far, and then there was the videotaped beating of Rodney King. I don't know that in those days it was so rare to capture one of these instances on videotapes. This was before the advent of cell phones, and that galvanized enormous protests, which we thought was going to lead to serious reform. It led to some reform, but not much. So I can say from personal experience that the shock value of the George Floyd video was most people were not desensitized, and it did have an enormous impact. In terms of whether we could become desensitized through exposure to media images, I've tried to study the literature there in communications, among communications experts, and there may be folks here who have that expertise. What I glean from the research is that it is so complicated how each one of us as an individual reacts to any particular media depiction, let alone a whole agglomeration of them, depends on countless factors about who we are, our background, our psyche, our beliefs, that it's impossible even to predict what the impact will be on one person, let alone a society-wide result. So let me give you one example, because people tend to think that, well, if people hear a message, they are in danger of absorbing that message. That's usually the kind of argument that's made against hate speech. We've got to stop people from saying hateful things because other people will then believe it, they'll adopt hateful ideas, and they'll engage in hateful conduct. Well, think of, in my recent experience, the most dramatic hateful expression to which I was subject was in Charlottesville in 2017, where you have the Unite the Right demonstrators marching with lighted tiki torches that they're brandishing against counter-demonstrators, chanting, "You will not replace us. Jews will not replace us." Talk about possible desensitization. I've repeated that countless times, and every time I still get chills up and down my body. What was the net impact of people seeing and hearing those chants? Do you think that most people became devotees of the Unite the Right and decided that they were going to crusade against Jews and against, the minority people that were supposedly threatening to replace us, the white supremacists? Or do you think most people reacted with revulsion and were galvanized to become more involved and committed to anti-racist activities? I mean, my hypothesis would be the latter.
Thank you. We have another question over here.
I have a question about social media. So those social media companies are private businesses and they're not technically subject to the First Amendment. Given the role they play in our increasingly digital society as these, for better or for worse, essential avenues for public communication, public discourse, do you think there's any room to interpret the First Amendment to include social media companies or other adjacent digital spaces to be regulated to not limit hate speech?
It's an excellent question, and it's one that is being debated and discussed by First Amendment experts, including Supreme Court justices. And the exact way that they formulate it is, and it's so complicated that people are advancing these as hypotheses and ideas for consideration. I don't know anybody who has firmly landed on a conclusion because they recognize that this is so complicated, we want to move fairly slowly. But the suggestion is that we should consider treating these companies, given their enormous power. I mean, their power exceeds that government has had in the past, right? And yet they're not subject to the constitutional checks that limit government. That's kind of a scary proposition in a democracy. When Twitter and Facebook deplatformed Donald Trump, who was then, indisputably still the duly elected president of the United States, commander-in-chief, you could say that Mark Zuckerberg had more power than Donald Trump. Because if Donald Trump violated people's free speech rights, we could go to court and sue him, which we did. But you couldn't bring a First Amendment lawsuit against Mark Zuckerberg. Donald Trump could be subject to impeachment, and he was, but nobody could impeach Mark Zuckerberg. Donald Trump could be subject to not being reelected. And he wasn't reelected, but nobody can unelect Mark Zuckerberg. So these are very, very serious problems. And what has been proposed is that these very powerful giant tech platforms should be treated as regulated public utilities or common carriers which are subject to a government mandate that they must not discriminate against any user or against any expression, that they have to be equally open, similar to the way the landline telephone companies were in the last century, or the telegraph companies before that, right? They couldn't discriminate. But that means they couldn't discriminate against hate speech either. You know, the KKK is allowed to communicate over these platforms as well as anybody else. And to my surprise, even libertarian economists and lawyers, Richard Epstein being a really good example, have suggested that this is a possibility that's worth considering. I have to say for myself as a civil libertarian who has a healthy skepticism of government regulation, even well-intended government regulation, I retain that. Even the best intended approaches, such as the so-called fairness doctrine that governed broadcast, had governed broadcast media in the 20th century. To the best of my knowledge, every study that's been done shows that it was enforced by every president in a predictable way to disproportionately punish those broadcast stations that were critical of that president's policies. So I would, the question is, whom do we distrust more? The powerful private sector entities with the possibility that competition will give rise to new companies. The ones that are dominant now won't always be dominant. Should we trust the market to give us other alternatives? Or should we trust Big Brother, whether it be Biden or Trump, to make those decisions?
Can I just follow up on that real quickly? Because I'd wondered if there was any, like an analogy to political parties, right? In parties in kind of mid-last century, who, right, eventually were classified as sort of quasi-public, and hence were subject to, right, equality provisions of the 14th Amendment and the like. Has anyone put anything like that
That's
out
a
there?
very interesting analogy. I would not be surprised if somebody, and you should write an article about that if nobody else has. I mean, it's a very, I will say this, that there is so much discussion that's going on, not only among lawyers and law professors and economists and other scholars, but also in Congress. There are many, many different proposals, and I think to its credit, including bipartisan proposals, but to their credit, they are moving very slowly. They kind of recognize that more damage can be done by moving too quickly. And I think that's what the Supreme Court is going to do. It's got a couple of cases that present similar issues, and I think the court is showing that it's going to decide as little as possible to let the situation evolve. We can learn more from experience.
Any other questions?
The moment has slightly passed, but the question that was asked back there around media desensitization, you ended that question by talking about how exposure to hateful ideas does not create more, does not increase the population, and you gave the example of the Charlotte.
That's not necessarily.
Okay, sorry, my apologies. I feel as though you also previously in your lecture mentioned that people chanting from the river to the sea just factually did not know what those words meant. And so slogans and mantras and vocal expressions are very easy to repeat without people knowing the context and the ideas behind them with which they hold. And then later when people associate themselves with that or say, no true Scotsman their way into associating with those ideas, they can gain power. So is exposure to these slogans that people pick up and use either to harm directly or to later facilitate direct harm, harm?
There's no doubt that speech causes harm in infinite ways, including the ways that you suggest. And one of many myths and misconceptions about freedom of speech is that it is posited on an assumption that speech does no harm. Nothing could be further from the truth, but thank you for giving me an opportunity to respond to that. The Supreme Court said in a case that involved hate speech, hateful speech, against LGBTQ people, against Catholics, against military. This was a case that, let me tell you about the case because it's so interesting. It involved a church, very different from the church that is represented here, called the Westboro Baptist Church, whose motto, please forgive me, I'm going to quote it, it's a slur, but their motto is God hates fags, all one word. And they demonstrated regularly outside the funerals of slain members of the U.S. military, ironically at a time when the military was still discriminating on the basis of sexual orientation. Westboro Baptist Church thought that the United States was not doing so well militarily because we were allowing gay people to serve. And so they would have these demonstrations where they were having ugly slogans against gay people, against Catholics, against military, basically anybody who wasn't a member of their church. And the Supreme Court held that, ugly as their views were, that was not a justification for suppressing them. And despite the fact that one of the people who found out about the demonstration, he didn't see it in real time, but he saw it on TV. His son had been a member of the military who had been killed, and they were demonstrating outside his funeral. And there was evidence that the father suffered not only emotional and psychic trauma, but that it was having an adverse physiological impact on him. And the Supreme Court acknowledged that. It repeated, there was only one dissent, by the way. These are issues, for better or worse, where the court, despite huge ideological divisions on other issues, are pretty much united on the principles that we've been talking about, viewpoint neutrality. The court acknowledged the harm that this speech can do, and it basically said, we defend freedom for hateful speech, not because we deny the power of speech to harm, for exactly the opposite reason. Because speech is so powerful, it can do great harm as well as great good. But in our society, we've reached the conclusion, and our government is premised on the conclusion, that it's more harmful to empower government to decide which messages are sufficiently harmful to be punished. So it's sort of like the least bad analysis, and thank you for giving me the opportunity to say that. And it's part of the reason why I feel so strongly that especially those of us who defend freedom for speech, including hateful speech, have a special responsibility to raise our voices, to denounce that hatred, to oppose it, to refute it, to educate against it, to do everything we can using our powers of free speech, which I ultimately believe are a much more effective way to hopefully change people's attitudes. And if I can, just for a second, not for a second, for a minute or two, not a soundbite, talk a little bit, the Westboro Baptist Church is a wonderful example of the power of what we lawyers often call counter speech, more speech rather than less. Megan Phelps Roper was a member of the Westboro Baptist Church, which is a family entity. It was founded by her grandfather, and basically the church members are all this long extended family. And it's like, it's like a cult. Her entire life was in this church, in this family. She started demonstrating at military funerals when she was just a tiny toddler. You can see pictures of her. She can barely stand. She's already demonstrating. And when she became older, like as a teenager in her young 20s, the social media was fairly new, and she was a young person, so the family said, we'll get her on Twitter, as it then was, to try to recruit followers to the church. Well, guess what happened? She goes on Twitter to try to recruit people into the church, and people start recruiting her away from her hateful ideology. And I know all of this because she wrote a wonderful memoir called Unfollow, Loving and Leaving the Westboro Baptist Church. It's a very, very powerful book. And basically, the main person who she interacted with was an Orthodox rabbi in Jerusalem who was not trying to punish her, not condemning her, not chastising her, not even preaching at her or teaching her directly. He engaged in what we in law school would call a Socratic dialogue with her. He asked her, well, which Bible verses do you rely on when you say that God hates fags? And so then she'd talk about the Bible verses, and he'd say, well, have you thought about interpreting it this way? Or have you thought about possibly, construing this word in that way? And got her to re-examine her family's interpretation. She ultimately weaned herself away, rejected and repudiated the family's views, left the church. I think she was about 25 when she did that. And you can imagine what it takes to do that when you're giving up your whole life, your whole family. You're entering into a larger world where you believe that you are going to be hated by everybody because you understand that you have been a hate monger. So it took an enormous amount of courage to do that. And she decided that she felt that she could never undo the harm that she had done, but that she would devote the rest of her life to trying to do that, to prevent other people from going down this rabbit hole of hatred. So that to me is just, and it's one of many examples. I mean, since I'm very concerned about what is an effective way to counter these hateful, harmful ideas, there's a whole genre of former leaders even, of white supremacist and other hateful organizations that have been weaned away, not through punishment, not even through cancellation, but through very patient and discussion and engagement and getting them to re-examine their own ideas.
Thank you. Are there any other questions? Oh, there's one in the back. Sorry. Hi, I wonder if we could continue the lovely infusion of neuroscience in the discussion. Thinking as an instructor, trying to do my best of neurally informed teaching practices related to the facts that just aggressive speech, not even hateful speech, inhibits frontal cortical activation, activates the amygdala, so we're responding from a fear point of view versus an understanding point of view. And I wonder, are there some ways that you think that we could utilize free speech, as you have expressed tonight, of encouraging that type of viewpoint in our instructional practices so that we are encouraging students, both in and outside the classrooms, to come from a place of more understanding versus tit for tat, because also with aggressive speech, you also increase dopamine reward circuitry that wants us just to spar because it activates that physiological response. So just wondering if you could touch a little bit more about that as well.
Wow, that's so interesting. Not being an expert on the neuroscience, it's interesting that coincides with my observation as a lawyer and as a professor. Let me tell you what I do in my classrooms, and it's a technique that is completely suited to legal instruction, but to me it would be suited to any classroom where we are trying to stimulate the process of critical inquiry, open exchange of views. And my mantra for my students is that they must be able to understand, articulate, and advocate all plausible perspectives on all issues. And it's very easy to do when you're talking about legal cases because you want the students to understand not only the majority opinion, but the dissenting opinion, not only the plaintiff's argument, but the defendant's argument. But I don't see any reason why this should not be the approach for all social sciences and humanities. And so, you know, and by plausible perspective, that means something that's not conclusory, not ad hominem, but based on analysis and based on evidence of the relevant authorities. And so in another class, you would ask a student, you know, what is the strongest argument for X? And the argument has to be based, as I say, on evidence and on reasoned analysis. Okay, that's a very good argument. Now, what is the strongest plausible argument you can make for not X? And not only does that strengthen the student's ability to understand and see the strength of differing perspectives, it also divorces the student from identifying personally with a particular perspective. Note that I'm not asking the students, what do you think? I'm asking you, in my case as a budding lawyer, but in other cases as you know, a student who is learning how to develop his or her thinking and articulation abilities, what is the strongest argument? And so that frees up students to express positions that they might actually share, but be uncomfortable sharing if they have to identify with it, if it's an unpopular perspective or they think it's going to be an unpopular perspective that's going to result in their being shunned by others. So I think if we nurture that approach of a responsibility to air different perspectives, and I think, you know, I don't know the brain science behind it, but I see a lot of joy on the part of my students when they find that they are unexpectedly able to argue two sides of an issue or to see some merit in a perspective that they hadn't previously grappled with. There's a great deal of positive reinforcement and excitement from that approach too.
Thank you. We have time for one last question.
But probably not for one last answer.
Well, let me, the discussant's prerogative of the final, maybe the final question or a request of you, Nadine. I don't want people to leave without you having the opportunity to exhort them on to become free speech advocates. What would you tell, especially the young people in the room, what can they do on our campus and beyond to cultivate an ethos of unfettered inquiry, freedom of expression? What would you tell them?
Oh, that's so such a wonderful invitation, David. As I was saying to the students with whom I had the pleasure of having dinner, the main impediment to realizing and actually enjoying meaningful freedom of speech on campuses around the country, and I suspect yours probably isn't that different, is students are really afraid of each other, and they're afraid of saying something that is going to be seen fairly or unfairly as offensive or insensitive or unpopular or controversial, and that will have at least adverse social consequences for them. And they fear that it might have even worse consequences, being ostracized or canceled, to use a common word. And that's an issue that cannot be solved from the top down, right? No matter how strongly protective the free speech principles of Hope College might be, no matter how supportive your professors might be of robust freedom of speech, if you're afraid of talking because of fear of what other students are going to do or say, it's the other students who have to assuage that fear. And social psychology studies show that we human beings are enormously prone to conformity, even to the point of ignoring our own senses and perceptions if we are in a minority because of an experiment where people are set up to give other answers. But the experiments also show that all it really takes is like one nonconformist, that the first nonconformist that stands up and bucks the tide makes it so much easier for the second one, and then it becomes much, much easier for the third one. It takes a lot of courage to be the first one, and I would not exhort anybody to do that, but maybe you can find a group of friends, people or with whom you share a seminar or, M&M or some other campus activity or group, and you can start talking, you have trust within that group that you are going to make a mutual pledge to discuss important but sensitive topics, and that you're not going to engage in unduly punitive conduct toward each other. And maybe that can create a ripple effect and spread to the campus as a whole. You have so much to gain. I know, I completely agree with this question and others. It means that you will be exposed to ideas that you will no doubt find, in some cases insulting and upsetting. But it also means that your net benefit is going to be incalculable in terms of maximizing the opportunity to take advantage of the wonderful educational programs that you have here, but also to go out into the world to act on behalf of whatever causes or concerns are of most importance to you. You can only do that effectively if you had experience and practice in free speech, not just as a theory, but as a lived reality.
Terrific. We will end it there. Please join me in thanking Nadine Strossen for a great night.
Thank you.